This is Bloomberg Law with June Grasso from Bloomberg Radio.
Every day from now until the election, we're giving out $1 million prize. And all you have to do is sign a petition in support of the Constitution. It's very straightforward. You don't even have to vote. You don't have to vote. You just have to sign a petition saying you believe in the Constitution.
The Department of Justice has warned Elon Musk that his pro-Trump PAC's $1 million a day sweepstakes targeting swing state voters might violate federal law. But now the Philadelphia district attorney has taken the first legal action against the sweepstakes. DA Larry Krasner is suing Musk and his PAC and asking a Pennsylvania state court to stop the illegal lottery, which, quote, lulls Philadelphia citizens and others in the Commonwealth to give up their personal identifying information and make a political pledge in exchange for the chance to win $1 million. Here's President Joe Biden's reaction after he cast his early vote in Delaware today.
Sir, Elon Musk is handing out checks to unregistered voters to register.
$1 million.
Do you think that's legal conduct? Do you think that's election interference?
I think it's totally inappropriate.
Joining me is election law expert Douglas Spencer, a professor of law at the University of Colorado. Explain the concerns about Musk's $1 million a day giveaway.
The concern is that Elon Musk is using this lottery to encourage voter registration and voting, which on its face doesn't sound bad. We want more people to be registered and to vote. It does promote democracy. But there are federal laws that prevent people from paying or buying votes or paying people to register. And so there's been allegations that this scheme that he has created is doing just that, rewarding people for registering and then turning out to vote. The DA in Philadelphia has raised a lawsuit is challenging this not just as a violation of these federal laws, but it sounds like there's also some state laws about consumer protection and some other issues related to fraud. There is some sense of seriousness about the allegations that these federal laws are being violated, which is why the Department of Justice itself has commenced an investigation. They haven't charged him with any crimes, but they see some of the concerns about the way this program is being run, and they're investigating it.
So the DA in Philadelphia is going on a different kind of track. He's saying that this is a lottery, and as such, it's illegal in Pennsylvania because all lotteries have to be operated and administered by the state. So he's trying to get around the questions about federal law.
That sounds right. There's been a concern about operating a lottery, and whether it's been regulated or registered or, as you said, is operated by the state itself. And then also, at least in the statement that I read, it says that the lottery is being used to kind of lull or dupe Philadelphians and Pennsylvanians into giving away their personal data in exchange for money, which could be a violation of, a state false advertising or some kind of consumer protection law.
I mean, it would put it into a whole different sphere because now he would have to follow all the rules for sweepstakes in Pennsylvania and the other swing states.
That's right. And what I don't know is in the state how to define a sweepstakes or a lottery because nobody's buying a ticket or giving Musk any cash in order to enter the lottery. They're entering the lottery by signing a political petition. And so, one, there could be an argument that the act of signing a petition is different than buying a lottery ticket, which would distinguish this. And secondly, the act of signing a petition is a First Amendment protected act that buying a lottery ticket is not. And so you'd have to see the interaction of this regulation of lotteries to the First Amendment. But if the state defines sweepstakes as, entering yourself for a chance to win a large sum of money based on chance or random draw, then this lottery is in violation of that state law if he has not properly registered or operating under those state regulations.
It's interesting. He also alleges, because Musk said that the winners are at random, and he said that appears false because multiple winners that have been selected are individuals who have shown up at Trump rallies in Pennsylvania.
Correct. So that's an allegation that in order to prove it, if a judge is willing to take the case, then one element of a lawsuit is what's called discovery. and Elon Musk would have to provide some evidence of the selection mechanism to prove that the decisions were being made randomly. He'd have to have a record of the random number generation or a video of him pulling a ping pong ball out. And if he's not, then he's not actually running a lottery, in which case he's falsely advertising what he's actually doing. But at the same time, if he's not randomly choosing people, then what he's doing may not be a lottery, and that could cut in favor of Elon Musk, because then he can say, I'm not actually violating the state's prohibition because I'm just giving money away to the people that I want to give money away to.
I know you don't know Pennsylvania courts per se, but do you think that they could move this quickly? I mean, Election Day is next week.
Yeah, I don't, because typically speaking, when you file charges against the state law, civil charges like this, the opposing party has 14 days to respond. The state courts will likely ask for a response much sooner, but that's basically the phase of the litigation we'd get to. We'd have an allegation in the public sphere. We'd have a response so we could say what the arguments are. There would be no time to hold a trial to do this kind of discovery unless a judge really decided it was in the public's interest to move extraordinarily quickly. But even 9 or 10 days, including weekends, is just too fast to pull this all off.
And as you mentioned, last week, the Justice Department sent Trump and his PAC a letter warning that this could be a violation of federal election law. And apparently Musk is ignoring it because he's still giving away million-dollar checks. So it doesn't appear so far that anything is going to stop him before Election Day.
I think the letter from the Department of Justice does two things. One, it's a public statement that lets everyone in the public know that what Elon Musk is doing may be a violation of the law. But under the federal law, a violation is punishable by a fine up to $10,000 unless you are knowingly and willingly violating the law, in which case then you can serve jail time up to 5 years. So I think this letter from the DOJ puts the PAC on notice that you are doing something willfully and knowingly, even though we've told you that what you're doing risks a violation, so that the potential penalties, which will come after the election in any case, could be much more serious, trying to get them to change. I will note that the lottery has changed a little bit since the DOJ sent its letter. It used to expire, eligibility used to expire on midnight October 21st, which was the deadline for voter registration in Pennsylvania, which was a really strong signal that the motivation for this lottery was to pay people to register, not something else. That deadline has now changed until Election Day. So there was some recognition that that was a problem for them, and they have changed their tactics a little bit. So they are aware and they're reading these letters, and the question will be after the fact if there's any accountability.
I mean, they also changed it a little bit in that he said at one of the giveaways, one of the early ones, that all you have to do is now be a spokesperson for us. So sort of making it into a job offer, I guess?
Correct. He's trying lots of different ways. A judge will have to determine whether or not they think that's his true intent or not. If I pay you to register to vote, but I also say that you have to walk outside and breathe fresh air, and then you get the money, a judge will say, I know you told me that you're paying these people for breathing fresh air, but they also have to register. I just think that's a scam. So the question is, for somebody signing a petition that doesn't ask for anything, just says, I think the First and Second Amendment are important, is that something that's a legitimate petition, or do we think that Musk has been using it as a way to insulate himself from just out and out buying people to register to vote to make it look somewhat differently? And that will be a fact determination by a judge. If it gets to this litigation, they can look at emails between Musk and his PAC and other communications. They can make determinations based on public statements where America PAC says we want to get 1 million people registered to vote in these swing states, and they'll make a determination whether or not that was the intent of this lottery, even though there are facts that cut in different directions.
A lot of people are going to say this is a move by a Democratic DA against Musk, who's spending millions to get Trump elected.
I will say I think the political side of this is as important as the legal side. So the Department of Justice sending this letter does send a signal for voters whether or not there's an actual violation, that what they're doing is a close violation of the law. And it could be the same for a district attorney who wants to make sure that this issue is framed in the press and in the political sphere as a legal mumbo jumbo as opposed to a really exciting money giveaway. So there's a political aspect where bringing these charges changes the news coverage, changes the dynamics, and that may be just as important as any finding of guilt or innocence. And so that's not something that the lawyers like me can really comment on, whether that's the right way to go about it, but there's definitely a political angle to this.
Do you remember anything else like this in our history, any kind of giveaways like this?
Not in our modern history. Way back in the 17 and 1800s, you used to have, this was before the ballot was secret, but you'd have parties who would basically give away free booze to people. You'd vote for their party, you'd get whiskey, and it's very well known. And in part to avoid that kind of bribery, we adopted the secret ballot. And since then, nothing so open as not driven by the parties. The parties, of course, are always trying to incentivize and motivate people to get out to vote, not with payments, but no lottery like this specifically from a wealthy billionaire either.
Thanks so much for joining me today. That's Douglas Spencer, a professor of law at the University of Colorado. A court hearing on the Philadelphia DA's application for a preliminary injunction against Musk and his PAC that would block them from continuing the sweepstakes is set for Friday morning in Philadelphia. Coming up next on the Bloomberg Law Show, we'll tell you what's next after a judge stopped the $8.5 billion Tapestry Capri merger. I'm June Grasso, and you're listening to Bloomberg. Today, Tapestry and Capri Holdings have filed their notice to appeal last Thursday's decision by a federal judge freezing Tapestry's $8.5 billion acquisition of Capri. The decision was a major victory for the FTC's chair, Lina Khan, who's tried to sink takeovers deemed anti-competitive in sectors ranging from tech to groceries with mixed results. The FTC sued to block the deal 6 months ago, saying it would eliminate direct competition between the fashion company's brands like Coach and Michael Kors in the so-called affordable luxury handbag market and hurt consumers. And the judge agreed following 7 days of testimony. Joining me is antitrust expert Harry First, a professor at NYU Law School. Harry, this was FTC Chair Lina Khan's first foray into fashion. How big a victory is this for her?
So it's a big case, important case, and your remark about fashion is good because the judge starts her opinion, as you know, with a great line, antitrust has come into fashion. So a nice double play on it's in fashion and it's in the fashion industry. So the FTC has been on sort of a bit of a successful run now, and this is one of those clear victories. In a case that in many ways is sort of a standard case, it's not far out legal theories, it's pretty close to sort of the middle of the road legal theories, but a big win spread over many pages in which clearly the judge liked what the FTC was doing.
Explain what the judge's reasoning was here.
So you have a number of particularly important questions, but a key question that starts out with is how do you define the product market? Who are the competitors? Because once you do that, sort of everything doesn't quite completely flow from it, but legally it goes in very orderly fashion. Use the fashion word again. So the critical question is the market all handbags? Or actually it starts out by saying, what's the definition of a handbag? So
I could answer that.
Right, yes. Trying not to use the where we're going in a handbag phrase. But, yeah, that seems like an obvious thing. But, that's the kind of thing, you have to define everything. So we've got these three different ideas of what handbags might be. And then a fourth. A fourth is all handbags, So a handbag has a function. So you could have a cheap handbag or a really expensive handbag, but they're all the same thing, and they're all in competition because consumers can decide among them. And then the FTC comes in and says, well, actually, you have three different types of handbags, and it depends in some large part, but not completely, on the price. So the mass market, which is fast fashion, accessible luxury, which is where the parties to the merger compete, and true luxury, really high luxury. I have to say I'm glad I don't have to buy these handbags because the true luxury handbags seem ridiculously expensive to me, in the thousands of dollars. These handbags that the parties make are not. They're sort of between $100 and $500. And a lot of the fight was, do we accept these divisions in the handbag market, or do we look at it all together? So the smaller you can make the market, the more you can focus on those divisions, particularly since these companies compete in that division. The higher the market share, the more concentrated the market, the more it looks like competition is going to be hurt.
Did she accept the FTC's determination that this would create a company where 59% share of the accessible luxury market would be controlled by this new company?
Yes, she did. So she accepted the definition, but she went through all the facts. You know, it wasn't just sort of, yeah, you're right, you know, I got it. She pretty meticulously went through a lot of the testimony, a lot of the documents. The documents, you know, slides, the reasons for the merger, the SEC filings. I love this. You know, they make filings to the SEC where they have to describe their business. What do they describe? They don't describe, you know, they describe this market. So they were caught every which way. Plus, she then discredited the merging parties' expert witness, saying that her testimony basically wasn't credible, and that, you know, these parties compete directly, the two brands that Tapestry controls and the one that Capri controls compete directly, and they compete in this segment of accessible luxury.
And was there correspondence that was kept confidential that she also referred to discredit some of the company's arguments?
Well, yeah, there was some redacted stuff, but there was a lot that was, you know, emails and, you know, and a lot of explanation of why the Tapestry wanted to acquire Kors and what they thought they could do with the brand. There were emails about pricing and how, you know, this was a race to the bottom because Kors keeps discounting, and my God, we've got a discount. So she relied a lot on what is called ordinary course documents, so documents that are kept in the ordinary course of business, as opposed to some of their, you know, the executives from these firms coming in and saying, oh, no, we compete against everybody, oh, no, you know, and, you know, trying to put a different face on what the reality was.
Tapestry and Capri say they're going to appeal the decision, but they have a February 10th expiration date on the deal.
Yeah, well, they have filed an appeal. You know, they're free to extend things if they think they've got a real shot at this or not. And, you know, I don't know what they're going to do, but I do think they're going to have a hard time getting this reversed. So, you know, if you were in management of these firms, you might be leery of extending this and, you know, staying in this limbo for a while, you know, while it works through the Court of Appeals.
This is a temporary measure that the judge has put into place here. They have to go through an administrative hearing, which is set for December 9th. I don't know how these things interact.
Well, it's a preliminary injunction. So the formal way of doing this is that the Federal Trade Commission itself tries the case in its own administrative court with an administrative law judge. But they have the power, in which they exercised here, to go into federal court to say, we want to stop this merger from happening so that we can adjudicate whether it's lawful or not, and we don't have to take the parties apart if we find it's unlawful. So we can keep them from merging until we make our final decision. So as a technical matter, this just keeps the status quo. They can't merge now until the FTC's administrative procedures are completed. Now, as a practical matter, most FTC merger cases not all, end up being decided at the preliminary injunction stage because parties can't wait around for, you know, the FTC to go through its own full hearing. and that may involve this appeal to the Court of Appeals. So if that's unsuccessful, if they do take the appeal and the Court of Appeals says, no, the preliminary injunction is correctly entered, then they would have to go to this hearing before the Federal Trade Commission's own administrative law judge.
I mean, I understand the Court of Appeals backup is something like a year. I mean, is there any way they could get a Court of Appeals decision before the February 10th expiration date of the deal?
To me, it seems highly unlikely. Forget whatever delay there is. I mean, normally it takes probably about a year to get from filing to decision. Maybe they could expedite it, but just simply the timing of filing a brief, the reply brief from the Federal Trade Commission, a reply brief to that, you're past February. So I don't see how they can get something from the Court of Appeals before that date passes. So they're going to have to figure out really what they want to do about this merger at this point.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with NYU law professor Harry First. What are the company's chances on appeal? Tapestry and Capri Holdings have filed their notice to jointly appeal the decision by a federal judge to temporarily halt the merger between the makers of Coach and Michael Kors handbags. I've been talking to antitrust expert Harry First, a professor at NYU Law School. So, Harry, as far as the in-house hearing, after you've had a judge give a 169-page ruling that really covered everything, I mean, what is left for the in-house hearing?
Hey, that's a great point. They could say, hey, why don't you just fax over that, they still use faxes, I guess, in the government. Just fax over that opinion and we'll just rubber stamp it. Well, what should happen, you have to have a hearing. So, you have to represent this evidence. It doesn't look good for, maybe you do it quickly, maybe you stipulate to the record, I don't know. But in any event, something has to happen that's some formal, and the administrative law judge has to then write an opinion, and it has to be well considered. Then that goes to the full commission for sort of an appeal process, and then it can be appealed to a court of appeals. So that process in itself also can be lengthy, and it can be a repeat of the hearing that they just had in federal court, which was held fairly quickly. And these days, every litigant is attacking the whole process in the Federal Trade Commission. So if they decide they've got all the time in the world, they'll probably go back into federal court and seek to enjoin the FTC from having this hearing, arguing that the Federal Trade Commission is completely unconstitutional. That's been how these cases have been going lately.
There was this whole thing that Capri might fail if this deal doesn't go through. Morningstar analyst David Schwartz said the whole business has been run to be sold for quite some time. They have to go back to square one. If Capri fails or is sold off, how does that affect, Lina Khan's big victory if you're losing one of the companies that's in competition here?
Well, we've had this in the airline industry, too, where recent merger blew Spirit, and Spirit is on the financial ropes. So the traditional antitrust answer is we have markets. So this company acquiring Capri, right, it wouldn't be a defense that they were a failing company. It might be a defense if they were a failing company. They never raised this defense that they were a failing company. So from the point of view of the antitrust court, they weren't. Whether they are in fact or aren't has yet to be seen. And if they can't maintain themselves as a separate business, the assets get sold in some way or another. Kors is still a brand. Maybe some other company will take it, or maybe the analysts are off, or who knows what exactly, and that's what markets will decide. But I think what the judge is saying, this particular solution, if it's a solution, may look good to Kors, but it does not look good to consumers. We're not in the business of trying to protect companies, is the antitrust answer is to protect competition.
If the deal falls apart, Tapestry will have to pay Capri as much as $50 million to reimburse merger expenses.
So there is a breakup fee. Aha.
Is that a breakup fee?
Yeah.
Because I was going to ask if merger expenses could be that much.
Gee, if it is, I'm in the wrong business. I should. I mean, that's a breakup fee, and sometimes companies use that to sort of invigorate their business. The classic case is AT&T T-Mobile, which fell apart, and T-Mobile got this big breakup fee, and then used it to reinvigorate its business. Again, the ins and outs of those things, from an antitrust point of view, these get negotiated among private parties, and it's an interesting view about how the parties saw the merger and maybe how much Tapestry wanted the merger. They were willing to risk that big breakup fee. In light of the documents, I don't get it. I mean, the documents were terrible from the point of view of Tapestry.
In what way?
Well, the documents basically saying what we've got to do is make consumers better off by raising the prices of Kors handbags. I mean, you don't really want to, go in and justify your merger by saying, this is really great, Judge. We'll be able to raise the prices. So, those women buying these bags will feel so much better now that they're getting the same darn bags, but paying more. So, I mean, that's how I read those documents, and those are the documents the judge quoted. So, I don't know.
When will they learn not to put things in emails? I don't know.
No, this wasn't in emails. These were slides to justify the deal. These were internal slides saying this is what we're trying to achieve.
Wow. Okay. Well, we see why the judge came out that way. So one FTC official said the ruling is an endorsement of its new merger guidance that the Biden administration put out. Do you think that is true?
So I think that's 80% true. In this sense, the judge at the beginning of her opinion says the defendants say no one's ever relied on those terrible guidelines, 2023 guidelines, but they just came out, and in fact the defendants were wrong that other courts have begun to cite them, and she then cites them a lot. So it's very clear that in certain ways, in particular, she was endorsing. There's one change that I think she did endorse, which is changing the threshold levels of when markets would be considered concentrated. The 2010 guidelines had raised those thresholds, and she said, all the other guidelines had lower thresholds. We're there, and we're there with the 2023 thresholds. On the other hand, this didn't push the thresholds. These numbers are bad under, any of the guidelines. So she did endorse the approach in that sense, but didn't have to really say this is a case that would have been okay under previous guidelines, but not under this, and I'm following these guidelines. That's why I say it's sort of 80%. She embraces them, but with numbers that are comfortable under any approach you can think of. And that's true of other parts of the theories as well, where, she cites them over and over again, but for propositions that, in a sense, are not that controversial.
She really did this quickly, yet we're still waiting for the Kroger-Albertsons decision, right?
Yes, that case has proceeded less quickly, and it's also more complicated with some state litigation as well going. There's one aspect that this case may help the Kroger-Albertsons decision for the FTC, because the judge in this case, Judge Roshan, looked at documents where the parties clearly were pre-merger, were taking account of competition from, looking at prices of the competitor who was acquired and saying, my God, they're putting pressure on us. So, the people who were running the Kate Spade brand, they were looking at Kors and Kors pricing and Coach brand, looking at Kors pricing. And there's similar evidence in Kroger-Albertson that they were very attuned to each other's pricing. So, this may be a little boost to the relevance of, that kind of head-to-head competition.
But you think that this decision is pretty solid, not likely to be overturned on appeal?
I think it's pretty hard to overturn it. She found the facts very clearly in favor of the FTC, went through methodically the weakness of the defense arguments. I think it'd be hard to overturn. And the legal approach she took is very standard on the nose, citing other district court opinions in the Second Circuit, other Court of Appeals, back to, a number of important Supreme Court cases. I think it's going to be really hard to reverse.
Always a pleasure to have you on, Harry. Thanks so much. That's Professor Harry First of NYU Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.